Well, there's a serious situation here, guys. I'm going to show you the actual complaint so you know what they're talking about. So, this comes out of the New York Law Journal. It was published on April 5th, 2019 by Tom McFarland. It says Queens judge greenlights claims over exploding Ecig battery. It says New York Supreme Court Judge Robert J. McDonald ruled that Mad Vapes Holdings, Vape Easy, and LG Chem would have to face claims that were negligent and failed to warn plaintiff Christina Williams about the allegedly defective lithium ion battery. Says a Queens County judge on Friday refused to dismiss three companies from a products liability suit stemming from an e-cigarette battery that exploded and caught fire in a woman's pocket. Let me pause this and show you the complaint. So what the judge did was they had a preliminary hearing and decided, okay, we have enough evidence to go to court. And so the judge okayed that the process can start. So they filed this complaint. They summoned the defendants. That's LG batteries across the board. Probably, I didn't read thoroughly this complaint, but I will in a moment here. Maybe there's going to specifically go after the battery that specifically exploded, or let's say allegedly exploded in her pocket. Also going after Mad Vapes, who probably sold the battery, and then Vape Easy. We'll see in a moment where they fall in the line. So what has to happen now is Mad Vapes, Vape Easy, and LG Chemical or LG Chem will need to answer this complaint, and I'm sure that the judge probably will give the green light to this, so it goes to trial. And probably what happened is it'll settle, but who knows? We'll see what happens. So, just want to share this with you, make this a little larger. So this is filed with the Queens County Clerk May 19th, 2016. And the index number is 705934 2016. Received New York State Certified Electronic Filing. I believe that's what the C is. I know EF is electronic filing. May 19th, 2016. So it's the Supreme Court of the State of New York, County of Queens. And it says a plaintiff designates Queens County as the place of trial. The basis of the venue is plaintiff's place of residence. It's a summons, and they even tell you the address. And my advice is don't harass this person at this address, okay? Anyway, so it's Katrina Williams, plaintiff against Vape Easy and LG Chem Limited defendants. So this is public information, so you can share this. Anyway, so it says to the above named defendants, you are hereby summoned to answer the complaint in this action and to serve a copy of your answer if the complaint is not served with this summons, to serve a notice of appearance on the plaintiff's attorneys within 20 days after the service of the summons, exclusive of the day of service. And you see that basically, and it's signed off by the plaintiff's attorney. That's just basic, summons service process. And we'll get into the heart of the matter. This is a verified complaint. This is the attorney firm. Sets forth the following upon information and belief. And so they talk about who's who, the parties. So the Vape Easy was a domestic business corporation authorized to conduct business in the state of New York. And Vape On and LG Chem. Even though that's mainly out of the Asian companies, either China or Japan, they certainly will have to. Yeah, here you go. So defendant LG, a foreign corporation, was doing business in the state of New York. So therefore, they have jurisdiction over this particular Asian company, and I've said that many a time. Guess what? This lawsuit was filed in New York, and LG will have to have what could happen. I mean, the process how it works anyway. The judge can actually subpoena the president of LG to actually appear in the New York State Court. Now, probably what will happen is LG's attorneys will appear on behalf of the of LG. But if they need to have LG testify or before the court or be deposed or whatever, depositions they could certainly go to Asia, and that'd be part of the court costs. Whoever wins the case the loser will have to pay those court costs. And that would be one of the court costs, is that to fly all the way over to Asia to depose a person, or they can come to New York and be deposed. But mainly, if they have to show up as a witness, they have to literally take their rear ends from Asia and wherever it's at, China, Japan, whatever, and come here and sit in an American court. Anyway, so let me pause this and do something real quick, and be back in a moment. So it reads, defendant's business activities on and before April 7, 2016. Defendant Vape operated, managed, and controlled a retail store for the purpose of selling for a profit vaping, smoking equipment, e-cigarettes, and related paraphernalia, including but not limited to batteries. On and before April 7, 2016, and you see, and it pretty much repeats itself, but anyway, LG was in the business, amongst other things, of designing, manufacturing, testing, selling, placing into the stream of commerce, and applying warnings to vapor, smoking equipment, e-cigarettes, batteries for vapor smoking equipment. On and before April 7, 2016, LG sold, distributed, marketed, and placed into the stream of commerce batteries to be used in vapor, smoking equipment, and e-cigarettes. And pretty much the same thing. On and before April 7, 2016, LG knew or should have known that the vapor batteries that it designed, actually it's funny, there should be really an O there, but it's okay, that it designed, manufactured, tested, sold, and placed in the stream of commerce could explode and cause a fire. On and before April 7, 2016, defendant LG, knowing that the vapor batteries that it designed, manufactured, tested, sold, and placed in the stream of commerce could explode and cause a fire and injury, should have provided necessary warnings and instructions for safe use and storage of its vapor batteries. Now, before I continue, let me explain something. The Food and Drug Administration, or the United States Health and Human Services Department, as well as the Center for Tobacco Products, they have yet to put any battery standards out there to United States and its territories. They say that what it reads in the FDA-funded rule in regards to vaping, it says that in regards to batteries, and they talk about batteries, but the only thing they say as far as batteries is that they will have battery workshops to figure out exactly what type of battery standards there will be. They've had, I think, 1 or 2 battery workshops already in the last year or two, but they have never put a final rule to those particular battery standards. So, as far as LG violating any of the federal statutes in regards to FDA battery standards, there is no violation. What there may very well be a violation on in regards to these necessary warnings and instructions is when it comes to the Federal Trade Commission. Now, the Federal Trade Commission can certainly kick in as well and go after LG. Not that they have specific battery standards with the Federal Trade Commission, but the consumers, American consumers and its territories, cannot be deceived. They must have certain warnings of certain products. So that can very well be brought up as they go along in this particular in this legal process. So I just want to point that out to you. Pretty much goes on in much the same concept. Anyway, facts of the incident. Before April 7, 2016, plaintiff Katrina Williams purchased a battery to be used in vape smoking equipment from the defendant, Vape Easy. And it's amazing how they, this law firm is not very well educated in law in regard, not law, in regards to terms of vaping, because they say smoking. It has nothing to do with smoking. It's vapor, but it's anyway. Anyway, let's continue on. Before April 7, 2016, plaintiff Katrina, I'm just going to say Williams. Plaintiff, or actually, I'm going to say plaintiff, because we know it's Williams. We should anyway, okay? By now. Plaintiff purchased a battery to be used in a vape smoking equipment from the defendant, Vape Easy, that was manufactured and sold by the defendant, LG. Plaintiff purchased a battery to be used from the defendant that failed to contain necessary warning and instructions for safe use, carrying, and storage. Plaintiff purchased a battery that was designed, boom, and you see the same thing. And you pretty much see the same thing. Plaintiff was carrying the defendant LG's battery to be used in vape smoking equipment that she purchased. Said battery suddenly exploded and caused a fire. Now, this is mainly, of course, user fault, okay? And the defendant, meaning all these parties, LG, etc., on down the line, are going to point out probably common sense for one thing. Like I buy all my batteries from IMR Batteries, and they have a slew. They have a list under all the batteries, every page you go to, of what you ought to do with batteries and what you ought not to. A lot of websites do have that. I don't know about Mad Vapes, but I'm sure they do. In fact, let me take a look and see what's going on here. Let me pause this and cross-reference a point. So, for instance, like IMR, I don't want to show you that yet. So IMR batteries, this is where I buy my batteries. My Samsung 18650 25 hours at, okay, and many other batteries. Now here you have LG HE4 18650 25 mile 28 battery. I don't know if this has anything to do with the case. It probably doesn't. I'm just using it as a perfect example. Okay. So this is IMR batteries. And when you scroll down, they have a list. Look at this, a list of what you should do and what you should not do when it comes to battery safety. And it says it right here. Do not store loose or in a pocket, purse, etc. Always use a protective case or box for storage and transport. So in this particular case, let's say if IMR Williams so happened to have bought a battery from IMR Batteries and put it in her pocket and exploded. IMR Batteries would not be held liable. They would have a simple defense. We have it right under the batteries. We can't help it if she doesn't know how to read, or she doesn't care to read, or whatever it may be. And of course, you bring all that out, all those facts out, see if she did read it or she didn't read it. But the point is that IMR Batteries had the information for the consumer. Now, when you go over to Mad Vapes, you go to the same exact battery, and there's nothing there. Look at that. There's nothing. And that's why they're being, right now, they have to answer the complaint. This is a perfect example. Perfect example. Let me pause this. And if you go to lgchem.com, they're talking about battery safety. LG Chem, right here. See? Boom. All right. Talking about e-cigarettes. On here. Now, the point is They're telling you certain things about batteries and says the batteries are not intended for sale to or use by consumers. So they can have somewhat of a defense, a pretty good defense by saying this. Okay, like it says, they are only intended for sale to and use by skilled manufacturers for products that incorporate necessary safety systems designed to protect end users from the known severe risks of fire and explosion associated with the misuse of individually ion cells. And see, that would fall. Now, Mad Vapes, they're going to get in trouble. They're going to get nailed for this because not only on their website, I mean, they have to at least have it on their website, like IMR batteries. See, this would get them off the hook on IMR batteries. Selling the same battery as this, but they don't have any, cautions, any telling you anything about the battery. Not good, not good at all. Not even in their terms and conditions of use. There's nothing in there about battery explosions. They're more concerned about making money and warranties and refunds and crap like that, but nothing about batteries. Nothing. Let's see. You got the warranty center. So, but nothing about anything about batteries. Now, you have to understand the FDA does not require them to do so, but the FTC does. And that's where they're going to get themselves into hot soup. Anyway, let's go back to that lawsuit. So it says on April 7, 2016, while plaintiff was carrying the defendant LG's battery to be used in vape smoking equipment that she purchased, defendant Vape Easy said battery suddenly exploded, caused a fire, and caused injury to plaintiff. The plaintiff was seriously injured, and then you can see pretty much it. And it says I just read it then. The occurrence on April 7, 2016, and the injuries and or serious injuries sustained by the plaintiff were due to the negligence, carelessness, and recklessness of the defendants and the defendant's failure to properly design, manufacture, test, and label the LG battery that was a dangerous and defective product, and the defendant's failure to provide proper warnings, instructions, and or to adequately warn of the hazards associated with the battery's use, carrying, and storage. Now, what probably the defendants, at least one of them, probably do is move for dismissal of the case via summary judgment and strictly deal with the law itself. What does the law say? So, what the defendant, let's say whoever moves for summary judgment, will say, okay, let's take it for granted that all the facts are correct. I agree. Yes, that's what happened. But let's look at the law. Like I said, the FDA does not have battery standards, does not have a final rule or law on batteries. So that's one thing out of the picture. FTC, Federal Trade Commission, as far as battery standards, no, they don't have anything on the books for that, but they can't deceive or create a deception in the consumer market. So, but especially considering the FDA doesn't have a battery standard, it's pretty much left up to the consumer or to the consumer market or to the people that are the merchants. Now, of course, states probably have certain also statutes on the books in regards to this stuff. But probably what's going to happen is the proper warnings. I can't highlight it. Sometimes PDF lets it, sometimes not. But the proper warnings, instructions, and or to adequately warn of the hazards about use and carrying and or storage, but mainly carrying because it exploded in her pocket. Apparently she did not know that. Now, common sense would tell you, you know, but maybe she thought it's no different than an alkaline battery. And if you put a double D battery or a double A battery in your pocket, it probably would not explode, even if a penny or a dime or a key cross between the bridged, made a bridge between the positive and the negative. Lithium ion batteries are much different battery. I remember when I was a kid, and I said this before in another battery explosion video that I did. You had AAs, triple A's, just thrown into a desk drawer with all kinds of pen points and metal points and all kinds of crap. Nothing ever happened. But lithium ion battery is much different. Maybe she didn't know the difference between that. It reminds me of that case a long time ago with McDonald's, and a person bought hot coffee and she burned herself with it, turned around, sued McDonald's, and won. And won. So that type of, and that was mainly from the Federal Trade Commission. I mean, she got her own lawyer, but still, it was mainly, they were citing Federal Trade Commission statutes in that case throughout the whole case. And that's what's going to probably kick in, is that to be a merchant within the American, United States and its territories, you have to have certain things in place to inform the consumer to make a proper decision. And so this is what's going to wind up kicking in place. And LG will be responsible, Mad Vapes will be responsible, and Vape Easy probably be responsible. And then they'll settle, and then, she'll walk away, have her hospital bills paid, and then go retire in the Bahamas. Anyway, so mainly, again, it sort of pretty much is, this law firm is pretty much just copy and pasting everything. Okay, now I mainly want to get to the law here. So it says the limitations on liability set forth in CPLR Section 1601 do not apply by reason of one or more of the exemptions, including defendants or jointly. This is all rules of the court. This is a whole different ball game. The second cause of action says at the time of the design, manufacture, testing, sale, and distribution into the stream of commerce, the vapor battery that was designed by boom was in a defective condition without adequate and sufficient safety guidelines, warnings, or instructions, and was dangerous to users in general. No, not really, no. I have batteries. I have plenty of batteries, but I know what to do with these batteries. The only thing possibly she could get, probably, if they move for summary judgment, let's say, all the defendants, let's say, move for summary judgment, maybe granted in part, denied in part, it would maybe probably be granted to the plaintiff that there were not guidelines or warnings or instructions as to how to use the battery. As far as it being a defective battery, the actual physical battery itself, well, for one thing, they would have to do some serious chemical analysis on that battery to prove that that is the plaintiff's attorneys, it's analysts and things of that nature. But yeah, these batteries are really good. If you leave a battery in a case, and you don't subject the battery to extreme cold or extreme hot, a battery will not just explode out of the blue. I mean, it can't happen. Anything is possible. You leave it in the charger or a pretty cheap piece of crap charger, could possibly explode. You leave it in the charger after it's fully charged, just let it sit there for a week. No, it might very well explode. Once it's charged, you take it out of the battery charger. You don't go, you don't put your batteries in the battery charger and then go on a vacation for a week. You don't do that. I mean, common sense tells you that, for one thing. I mean, this plaintiff ought to know that, I don't know what kind of device she was really using, but she should know that the device itself is very, complex. So therefore, it's a complex battery. You would think common sense would tell you to be careful with this particular battery. So that's pretty much it. I don't need to go. I think you get the gist of it. I don't want this video to go too long. And then you got third cause of action. So it says plaintiff relied upon the skill and judgment of defendants Vape and LG and the representations and warranties in connection with the use of said vapor battery. Let me just pause this and look at Vapor Easy or Vape Easy. So this is out of New York, Vape Easy, New York. It doesn't have too much on here actually. It says battery safety. I don't know when this was posted. Um, I mean, this could possibly help them out. I don't know if she bought it inside this shop. I mean, apparently it has its own shop. Looks like it has a shop. This is what the Vape Easy shop looks like. I don't know if she bought it online or if she bought it inside the shop. Um, but it does have this little thing right, right here about battery safety in there. So it's a link that goes to that. And it's quoting AMV reviews back in October 16, 2013. I don't know if this was posted after the lawsuit was filed or before, or really before their judge's order or not. Can't tell you. So they don't even seem to have anything for sale online. It's probably mainly it's mainly in the shop you buy it, probably. Doesn't look like they got maybe e-juice. Got CBD, Nick Salt, but they don't have any hardware to buy. No batteries to buy online, unless they stopped it after the judge's order. Um, but anyway, that's what it looks like. But it doesn't say anything about batteries, so except for that one video. But I don't know if that was posted before the judge's order or not. If it was posted, in other words, if that was on the website before the judge's order, then they're safe. That is Vape Easy at least informed the public in regards to battery safety. But if it was put up there after the judge's order, then don't count. But I don't know what they exactly do inside that particular vape shop, so who knows? And I would prefer vape shops to inform the consumer. But see, part of the problem about it, and this is going to be one of the most solid defenses they have as far as Vape Easy is concerned, or even Mad Vapes, but mainly Vape Easy, is that to inform your consumer about the battery, you would be you'd be violating FDA rules / regulations / laws. That is, you cannot make health claims. And I know it sounds crazy, but you can't give any informative. You can't say, well, use this battery this way, use this battery that way. The retailer hands are tied; they can't do it. And I think that would be the best defense they could use, as far as the. But if they could, they probably maybe would have explained about the battery. But a lot of this stuff comes down to common sense, you know. But anyways, so it says said representations and warranties were false, misleading, and inaccurate in that the vapor battery was unsafe, unsound, unsuitable, not fit for the purposes for which it was intended and utilized, and was defective, unsafe, dangerous, and not of merchantable quality. Now, in a way, I can understand what they're saying there, because if we go back over to the website here, as far as where was I at over here? Let's see. No. Okay, LG. Like it says over here, LG is saying that their Leon cells, or the batteries, are not intended for sale to or use by consumers. And the main key to here is sale to consumers. Understand? So that could possibly get even LG off the hook. See, because they're saying the plaintiff's attorneys are saying it was not intended to be used by the plaintiff. So how did she get that particular item, that battery? So then that would wind up falling on Vape Easy for selling that battery. But then again, there are no battery standards. So, this is all has to be worked out. And that's why usually these kinds of cases will settle out because there's a little bit give and a little bit of take. In other words, even the plaintiff's in the wrong, as well as LG, Mad Vapes, and Vape Easy. So, and then the rest is the West. So, force calls of action. The battery was not safe and it did not meet a reasonable consumer's expectation as to the manner in which a vapor should perform and the level of protection that should have been expected and provided. Well, no, I don't, once again, I don't know, and this will come out during the court documents as they go back and forth. I don't know what she was vaping on. Let's say she was vaping on 2-mecmod. She should know that the battery, I mean, she should know like it says, the manner in which to use that battery. You're using a 2-mecmod. Regulated device, yeah. But common sense will tell you to not put a battery in your pocket. I'm sure the battery that was in the pocket. Now, they don't give you the full facts, and that'll come out eventually in the court documents. Let's say the battery was in her pocket, but nothing else was in the pocket. Probably that battery would have been all right, unless it was bumped up against something or something like that, or pressed up against something, or it was too hot or too cold. But once you put keys and change and dimes and quarters inside of your pocket, then you're looking for trouble. But all of this stuff will come out. So, like I said, you'll see eventually they settle these cases because the plaintiff's going to realize it's partly her fault, partly LG's fault, partly Mad Vape's fault, and partly Vape Easy's fault, and therefore they settle. And pretty much the rest of it. And then it says defendants, Vape Easy and LG's conduct was willful and wanton and demonstrated a reckless disregard for the safety of others. I mean, that's just a bit much, but whatever, is entitled to recover punitive damages in an amount to be determined by a jury together with the costs and disbursements of this action. And, they always request juries. I mean, that's one of your rights to do so. And that's the attorney on it, and was filed it was written up May 19, 2016. So this has been laying around. So apparently this has been going back and forth with the motions because they were probably LG, Vape Easy, and Mad Vapes trying to dismiss this case. They probably did a summary judgment. In other words, as soon as the complaint was filed and was served, they probably made for summary judgment to try to get it tossed out. And then the judge says, no, it's not going to be tossed out. And you have to answer the complaint. Now they can move for a summary judgment to dismiss again or answer the complaint. So, and that's pretty much it. And that's just whatever. So I just want to share that with you. And we'll see what happens with this particular case. I'm sure as things develop. But this is serious because it just gives more oomph for the FDA to have battery standards across the board. And they have the power. The FDA actually has the power to restrict batteries being sold to consumers without a business license or a business address. They can actually do that. They have the power to do that. It's in the FDA final rule. They just haven't yet figured out what the battery standards are. So these types of cases we ought to be concerned about, because if the FDA ever decides to have battery standards, and one of the battery standards is that these 18650s, 26650s, whatever they may be, lithium-ion batteries or whatever, it can be any battery that the FDA decides to go after, can only be sold to a person that has a business license or a business address. Anyway, I just want to share all this with you and keep you in the loop. You guys have a good one. Bye-bye.